I need you to stop whatever you are doing right now. I need you to put down your phone or sit back from your screen or pause whatever else is competing for your attention in this moment. Because what I am about to tell you is not a story about a petty neighbor with a clipboard. It is not a story about an unreasonable fine or an absurd rule or a power-hungry board member making someone's life difficult over a welcome mat or a paint color or a parking spot. This is a story about a family that almost lost their home. Not almost lost it in the sense of a dramatic metaphor. Not almost lost it in the sense of things got really stressful and uncomfortable. Almost lost it in the most literal, legal, documented sense of those words. A family that received a notice in the mail informing them that the organization governing their neighborhood intended to place a lien on their property and initiate foreclosure proceedings over an unpaid fine of $200. $200. Let me put that in perspective for you. The median home value in the neighborhood where this story takes place is approximately $340,000. The HOA was prepared to initiate a legal process that could have ultimately stripped a family of a $340,000 asset over a fine that you could pay with the cash in most people's wallets right now. A fine that, as we are going to discover, the family did not even legitimately owe. Now I know what some of you are thinking. HOAs cannot actually foreclose on your home over a small fine. That is not a real thing. That sounds like an urban legend. That sounds like something people say to scare you about HOAs, but that does not actually happen in real life. I need you to understand something before this story goes any further. HOA foreclosure is absolutely a real thing. It happens in the United States every year. In the majority of states, a homeowners association has the legal authority to place a lien on your property for unpaid dues or fines and to initiate foreclosure proceedings to enforce that lien. Some states have passed laws limiting this power, requiring minimum debt amounts or mandatory notice periods or judicial oversight before an HOA can proceed with foreclosure. But in many states, the protections are limited. And in the state where this story takes place, at the time this story took place, the protections were not enough to prevent what nearly happened to the Rodriguez family. Yes, I said the Rodriguez family, because the people at the center of this story gave me permission to use their real first names. They wanted this story told with their names attached. They wanted it on the record. They wanted anyone who searched their HOA's name to find this story. They had nothing to be ashamed of, and they had every reason to want the truth documented. Their names are Miguel and Rosa. They have been married for 19 years. They have 3 children, a 17-year-old son named Carlos, a 14-year-old daughter named Isabella, and an 11-year-old son named Daniel. They have lived in the same house in the same neighborhood for 11 years. They bought that house with money Miguel earned over 15 years of working in construction management. Money Rosa contributed from her 12 years as a school administrator. Money saved carefully and deliberately by 2 people who understood exactly what owning a home meant and exactly what it would take to keep it. This is their story. And by the time it is over, you're going to understand something about HOA power in America that most people do not understand until it's too late. Welcome to the HOA Files. Miguel and Rosa Rodriguez bought their home in a community called Sunrise Pines 11 years before this story takes place. Sunrise Pines is a planned community in the southeastern United States, a state with warm weather, strong HOA culture. At the time of this story, HOA governance laws that gave associations significantly more power than many homeowners realized when they signed their purchase agreements. Sunrise Pines has 218 homes. Single-family homes ranging from modest 3-bedroom ranch styles to larger 4- and 5-bedroom 2-story properties. The Rodriguez home is a 4-bedroom 2-story with a 2-car garage, a screened back porch, and a small but carefully maintained front yard that Rosa tends herself on weekends. It sits on a quiet cul-de-sac near the back of the community, which Miguel specifically chose when they were house hunting because he wanted the kids to be able to play outside without worrying about through traffic. The neighborhood is genuinely pretty. Tall, slash pines, and live oaks throughout the community give it a natural feel that contrasts pleasantly with the manicured landscaping requirements. There's a community pool that the kids use constantly when they were younger. A fitness center in the clubhouse. A small playground near the entrance. Monthly HOA fees of $225 cover maintenance of all these amenities, plus the community landscaping and an assortment of administrative costs. For the first 9 years of living in Sunrise Pines, Miguel and Rosa had almost no interaction with the HOA beyond paying their monthly fees. They maintained their property meticulously. They followed the rules. They attended occasional community events. They were the kind of neighbors that every community wants, present and invested, but not intrusive, respectful of the shared space and of their neighbors' privacy, the kind of family whose presence makes a neighborhood better. The HOA board during most of those 9 years was a rotating group of homeowners that Miguel and Rosa knew mostly by sight. Nothing remarkable. Nothing particularly good or particularly bad. Just people doing a job that nobody else wanted to do, which is how most HOA boards operate when things are going reasonably well. But about 2 years before this story's central events, the composition of the Sunrise Pines board changed. A new board president was elected, a man I'm going to call Richard, who had moved into the community about 3 years prior and had immediately become involved in HOA governance with an enthusiasm that several long-term residents privately described to me as concerning from the very beginning. Richard was in his mid-60s, recently retired from a career in finance, and he brought to the HOA presidency a very specific management philosophy that had presumably served him well in finance, but that was spectacularly ill-suited to the governance of a residential community. He believed in strict enforcement. He believed in zero tolerance. He believed that rules existed to be followed without exception and that any deviation, regardless of context or circumstance or degree, warranted the full weight of the enforcement mechanisms available to the association. Under Richard's leadership, the Sunrise Pines HOA began issuing more violation notices than it ever had before. Fine revenue, which had historically been minimal because violations had historically been minimal, began to increase. The management company, which had a financial arrangement that included a percentage of fine revenue, was supportive of Richard's enforcement-heavy approach. And Richard had found, in the fine and lien and foreclosure provisions of the Sunrise Pines CC and RS, and the state law governing HOA operations, a set of tools that gave him an extraordinary amount of power over his neighbors. Power that he was, as this story will show, prepared to use to its absolute legal maximum. It started, as these stories so often do, with something small. Something so small that Miguel and Rosa's first reaction was that there must be a misunderstanding. It was a Saturday morning in late spring. Miguel was in the garage working on a project. Rosa was in the kitchen with the kids. Carlos, who was 16 at the time, had parked his recently acquired used car on the street in front of the house the night before because Miguel's work truck was taking up one of the driveway spots. The car had been there overnight and through the morning. Around 11 o'clock, Miguel found a violation notice tucked under the windshield wiper of Carlos's car. The notice cited a Sunrise Pines parking regulation that prohibited vehicles from being parked on the street for longer than 12 consecutive hours. Carlos's car had been there for approximately 14 hours. The fine was $200. Miguel read the notice twice. He felt a flash of irritation, but tamped it down. He was a reasonable person. He knew the rules existed for a reason. He had not been aware of the 12-hour street parking limit, but that was his own oversight. He brought the notice inside and told Rosa about it. Rosa looked at the notice and then asked Miguel a question that, in retrospect, was exactly the right question. She asked when they had received any prior warning. Miguel looked at the notice again. It did not reference a prior warning. It went directly to a $200 fine. He pulled up the Sunrise Pines CC and RS on his phone. He found the parking section. The parking regulations did include a 12-hour consecutive street parking limit. But directly below that provision was the fine schedule for parking violations. The fine schedule specified that a first offense parking violation would result in a written warning. A second offense within 12 months would result in a $50 fine. A third offense within 12 months would result to a $100 fine. A fourth and subsequent offense would result in a $200 fine. Carlos's car had never received a parking violation before. This was a first offense. The fine schedule clearly stated that a first offense received a written warning, not a $200 fine. Miguel called the HOA management company on Monday morning. He was calm and polite. He explained the situation, referenced the fine schedule in the governing documents, and asked for the violation to be corrected to a written warning as specified. The woman he spoke to said she would look into it and call him back. She did not call back. Miguel called again on Wednesday. He was transferred to a different person who said the fine had been properly assessed and that any appeal would need to be submitted in writing to the board. Miguel submitted a written appeal that week. He referenced the fine schedule. He documented that this was a first offense. He was thorough and polite and completely confident that the appeal would be resolved in his favor because his position was clearly correct. He did not hear back for 3 weeks. When the response finally arrived, it was a single-paragraph letter from the management company stating that the board had reviewed his appeal and determined that the fine had been correctly assessed and that no adjustment would be made. No explanation. No acknowledgement of the fine schedule discrepancy. No response to the specific argument Miguel had made. Just a form letter denial. Miguel read the letter at his kitchen table. Rosa was beside him. They looked at each other. $200 was not nothing in their household budget. But more than the money, it was the principle. Miguel knew he was right. He had the governing documents. He had the fine schedule. He had documentation that this was a first offense. The HOA had no legitimate grounds to assess a $200 fine for a first parking violation. He decided not to pay. He was not being reckless. He was not being defiant for the sake of defiance. He was making a calculated, principled decision based on his documented understanding that the fine had been improperly assessed and that paying it would be an acknowledgement that the assessment was correct when it clearly was not. He had no idea what that decision was about to cost him. The first indication that something had gone beyond a normal fine dispute came about 6 weeks after Miguel's appeal was denied. He was checking the mail on a Tuesday evening after work and found an envelope from the Sunrise Pines HOA management company. He opened it at the mailbox. It was a notice of a late payment penalty. The original $200 fine had been assessed a $50 late fee, bringing the total to $250. The notice stated that the outstanding balance was now due immediately and that failure to pay within 30 days would result in additional penalties. Miguel went inside and sat down at the kitchen table. He told Rosa what the notice said. Rosa asked if they should just pay it to make it go away. Miguel thought about it for a long moment. He said no. He said that paying a fine that had been improperly assessed, with a late fee on top of it, felt like letting something wrong become right simply because fighting it was inconvenient. He said he wanted to understand what his options were first. He called a neighbor who had been on the HOA board several years earlier and had a general understanding of how things worked. The neighbor told him about the formal dispute process and suggested he document everything very carefully. The neighbor also mentioned, almost as an aside, something that hit Miguel like a bucket of cold water. He mentioned that under the Sunrise Pines governing documents and the relevant state law, unpaid HOA assessments, including fines, could be subject to a lien on the property. Miguel asked the neighbor to repeat that. The neighbor repeated it. He said that technically, if an HOA assessment went unpaid long enough, the HOA had the ability to place a lien on the property. He said he had never seen it happen in Sunrise Pines over a small amount, that it was generally reserved for situations involving thousands of dollars in unpaid dues, but that theoretically the mechanism existed. Miguel thanked him and went back inside. He sat with that information for several days. The idea that a $200 fine dispute could theoretically connect to his home through a legal mechanism felt deeply unsettling. He pushed the thought aside because it seemed too extreme to be realistic. $200. Nobody was going to threaten his home over $200. He sent a second written appeal to the board, this time more detailed. He laid out the timeline. He referenced the fine schedule in the governing documents and cited the specific provision that required a written warning for a first parking offense. He noted that he had received no prior warning. He requested that the fine and the late penalty be withdrawn entirely and that the matter be resolved with the written warning that should have been issued in the first place. 3 weeks later, he received another form letter denial, identical in substance to the first one. No engagement with his arguments. No acknowledgement of the fine schedule. Just a denial. The outstanding balance had now grown to $300 with an additional penalty. Miguel started keeping a file. Copies of every notice, every letter, every email, every phone log entry from his calls with the management company. He did not have a documentation system as sophisticated as Jennifer's, but he had the instincts of a man who had managed construction projects for 15 years and understood the value of keeping records. Everything went into a manila folder in his home office. He also started paying more attention to what was happening in the neighborhood. He began to notice that he was not the only Sunrise Pines resident dealing with escalating fine disputes under Richard's leadership. He heard from a neighbor 2 streets over who had received a violation for grass that was allegedly 1 inch too tall, according to the HOA inspector's measurement. He heard from a woman on the other side of the community who had been fined for a wind chime that was visible from the street. He heard from an older couple who had been battling a series of fines for what Richard claimed were unauthorized landscaping modifications. The pattern was becoming visible to Miguel even before he had the language to describe it precisely. Aggressive enforcement, improperly assessed fines, denial of legitimate appeals, escalating penalties on disputed charges, and underlying all of it, a new board president who seemed to view the fine and penalty mechanisms not as last resort enforcement tools, but as the primary instrument of community governance. Miguel brought all of this to Rosa one evening. He spread the folder on the kitchen table and walked her through everything. Rosa listened carefully. When he finished, she was quiet for a moment. Then she said something that Miguel has told me he has thought about many times since. She said that in her 12 years as a school administrator, she had learned to recognize the difference between institutions that made mistakes and corrected them and institutions that made mistakes and doubled down on them. She said that every interaction they had had with this HOA since the first notice had followed the pattern of an institution doubling down. And she said that when an institution doubles down consistently, it usually keeps going until someone makes it stop. She told Miguel to find a lawyer. Miguel called 3 attorneys over the following 2 weeks. The first was a general practice attorney who said HOA matters were not really her area and referred him elsewhere. The second was an HOA attorney who was very busy and could not take on new clients for several months. The third was a property and HOA law specialist named David, a soft-spoken man in his early 50s who had been practicing in the state for over 25 years and who, when Miguel finished describing his situation, asked him one question before saying anything else. He asked Miguel whether he had received any notice about a lien. Miguel said no, not yet. He asked why. David said that in the state where Sunrise Pines was located, HOA assessment debts, including fines, had the legal status of an assessment lien the moment they became past due. He said that unlike some states that required a formal separate lien filing process, the state where Miguel lived allowed HOA liens to attach automatically to the property upon default without any additional action by the HOA. He said that based on what Miguel had described, there was a real possibility that a lien had already attached to the Rodriguez property, even if Miguel had not received formal notice of it. Miguel was very still for a moment on the phone. Then he asked David to explain exactly what that meant. David explained. An HOA assessment lien was a legal claim against the property. It meant that the property could not be sold or refinanced without first satisfying the lien. If the lien remained unpaid long enough and the HOA chose to enforce it, they had the legal mechanism to initiate foreclosure proceedings. In the state where Sunrise Pines was located, the law at the time of this story did not require the HOA debt to reach any minimum amount before foreclosure could be initiated. There was no statutory floor of $10,000 or $5,000 or any other amount. The law provided for a mandatory notice period before foreclosure could proceed, but the notice requirement was administrative rather than substantive. It did not give the homeowner a right to challenge the underlying debt in the notice process. Miguel sat down. He had been standing in his kitchen while making this call. His legs felt suddenly unsteady, and he sat down in the nearest chair. He asked David how this was possible. How could a $200 fine dispute lead to foreclosure? David said that it happened. Not frequently, but it happened. He said it happened in situations where the homeowner did not pay, where the debt escalated with penalties and interest and attorney fees, and where the HOA board had either not considered or not been deterred by the disproportionality of the outcome. He said that some HOA boards, particularly under aggressive leadership, had initiated foreclosure proceedings over amounts that most people would consider trivially small compared to the value of the home. David asked Miguel how large the outstanding balance was at this point. Miguel told him, $300 plus whatever additional penalties had accrued. David was quiet for a moment. Then he said he wanted to take Miguel's case. He said the fine had been improperly assessed, which Miguel already knew and could document. He said the escalation of the fine, with late fees and penalties on a disputed amount, raised additional legal issues. And he said he wanted to act quickly, because if a lien had already attached to the property, the urgency of the situation was higher than it would otherwise be. Miguel hired David that week. He went home and told Rosa. Rosa had been the one who told him to find a lawyer. But hearing it out loud now, the specific words David had used, the concept of the lien that may have already attached, the theoretical pathway from a disputed $200 parking fine to foreclosure on the home where her children had grown up, made Rosa's face do something Miguel had never seen it do before. Not panic. Rosa was not a person who panicked. Something quieter and more frightening than panic. A kind of recognition. The recognition of someone who has just understood the full scale of what they are facing. Carlos came downstairs while they were talking and asked what was going on. Miguel and Rosa looked at each other. Miguel told Carlos that there was a situation with the HOA that they were handling and that everything was going to be okay. Carlos nodded and went back upstairs. He was 16. He knew that when his parents said everything was going to be okay in that particular tone of voice, it meant things were not currently okay. David moved quickly. Within 4 days of being retained, he had submitted a formal records request to the Sunrise Pines HOA management company requesting all documents related to the Rodriguez property, all board meeting minutes from the preceding 2 years, the complete fine schedule as currently adopted, all records related to the adoption of any amendments to the fine schedule, and all records related to any lien status on the Rodriguez property. He also filed an official title search on the Rodriguez property. The results came back within 48 hours. There was a lien. An HOA assessment lien had been filed against the Rodriguez property approximately 3 weeks earlier, while Miguel's second appeal was still ostensibly under review, without any notification to Miguel or Rosa that this action had been taken or was being contemplated. The lien amount was $425. The original $200 fine, plus 2 cycles of late fees, plus a $25 lien filing fee that the management company had charged to the Rodriguez account. David called Miguel immediately when he received the title search results. He said the situation had just become significantly more serious and that Miguel needed to understand several things. First, the lien was real and it was attached to their property. Until it was resolved, it encumbered the title. This meant that if Miguel and Rosa ever tried to sell or refinance their home, the lien would have to be satisfied first. Second, under the state's HOA statute, the HOA now had the legal mechanism to accelerate toward foreclosure if the lien remained unsatisfied. The statute required a specific notice and waiting period before foreclosure proceedings could be initiated, but that clock had potentially already started running when the lien was filed. Third, the lien had been filed without notifying Miguel and Rosa in advance, which David believed was a procedural problem. The state statute required that homeowners be given written notice of the HOA's intent to file a lien before the lien was actually filed, allowing a cure period during which the homeowner could pay the disputed amount. David had not yet received all the records he had requested, but he needed to determine whether this required pre-lien notice had been sent and whether Miguel had received it. Miguel checked his records carefully. He had kept every piece of mail from the HOA. There was no pre-lien notice. He had received the fine notice, the late fee notice, and the 2 appeal denial letters. Nothing had warned him that the HOA was about to file a lien against his home. This was significant. If the state statute required pre-lien notice and no pre-lien notice had been given, the lien itself had been improperly filed and was potentially void. David sent an immediate follow-up records request, specifically asking for copies of any and all pre-lien notices sent to the Rodriguez property. The management company responded within a week. Their response included what they claimed was a copy of the pre-lien notice, a letter supposedly mailed to the Rodriguez home approximately 6 weeks before the lien was filed. Miguel had never received it. David hired a mail verification service to investigate the mailing history. What the investigation found was inconclusive regarding whether the letter had actually been mailed, but it established clearly that Miguel had not signed for any certified mail from the HOA during the relevant period. The alleged pre-lien notice had supposedly been sent by regular first-class mail with no tracking or confirmation of delivery. There was no proof it had ever been mailed. There was no proof it had ever been received. In Miguel's complete file of every HOA communication he had received contained no such letter. David added this to the growing list of procedural problems with the HOA's actions. The records request also produced something else significant. The board meeting minutes from the period when Richard had taken over as president contained detailed discussions about the HOA's enforcement philosophy. One set of minutes from a meeting held about 6 months after Richard took office contained a passage where Richard had discussed what he called the association's revenue optimization strategy, a phrase that David read aloud to Miguel over the phone with the specific deliberate quality of someone who wants to make sure the full weight of a phrase is heard and understood. Revenue optimization. For an HOA, in a discussion about fine enforcement, the board had been discussing fines not as a reluctant enforcement mechanism, but as a revenue stream. The minutes documented Richard's presentation of data showing fine revenue under previous boards and his projection of increased fine revenue under the enforcement protocols he was implementing. He had described the HOA's fine and lien authorities as underutilized assets. Underutilized assets. Miguel's $200 parking fine, the fine that was about to threaten his family's home, had been generated by a board president who had explicitly discussed HOA enforcement mechanisms as revenue optimization tools. David sat with this for a long time before calling Miguel. He told Miguel that what he had found in those board meeting minutes was not just evidence in the Rodriguez case specifically. It was evidence of a systematic governance philosophy that potentially affected every homeowner in Sunrise Pines. He said this changed the scope of what needed to happen. He said they needed to fight this hard, and he said they needed other homeowners. Miguel was not by nature a confrontational person. He was a builder, a man who solved problems by rolling up his sleeves and working through them methodically and practically. He did not enjoy conflict. He did not seek drama. He had spent 11 years in Sunrise Pines as a good neighbor and a quiet presence, and he had genuinely not wanted any of this. But David was right, and Miguel knew he was right. The board meeting minutes that David had found were not just about the Rodriguez family. They were about the governance philosophy of an entire community. And the families living in that community deserved to know what their HOA board president had described as the philosophy he was bringing to the enforcement of the rules that govern their homes and their property. Miguel started talking to his neighbors, carefully at first, then more openly as he found that the response was consistently one of recognition. Nearly every homeowner he spoke to had experienced something in the preceding 2 years that had felt wrong. A fine that seemed disproportionate. An appeal that was denied without explanation. A violation notice for something that neighbors in identical situations had not been cited for. An enforcement action that felt personal rather than procedural. He found a family 2 streets over who had received a series of fines totaling over $800 for what the HOA inspector had described as landscaping inconsistencies. The family had paid every fine under protest because they were afraid of exactly what Miguel was now facing with the lien. They had paid money they did not owe because the threat of escalation felt too frightening to resist. He found a retired teacher named Margaret who had received a fine for a small American flag display that she had maintained on her front porch for years without any prior complaint, only to suddenly be cited under a signage ordinance that had apparently been reinterpreted under Richard's leadership to include decorative patriotic displays. He found a young family, first-time homeowners who had moved into Sunrise Pines only 18 months earlier, who had received 4 separate violation notices in their first year of homeownership, all for things they had not known were violations, none of which had been preceded by the courtesy of a warning that the governing documents actually required for first offenses. He found an elderly widow named Eleanor who lived alone in a 3-bedroom home she had shared with her late husband for 17 years. Eleanor had received a lien notice 6 months earlier for unpaid fines totaling $612. Eleanor, who was 81 years old and whose primary income was Social Security and a small pension, had been terrified. She had borrowed money from her adult daughter to pay the full amount immediately because she was afraid of losing her home. She had paid a debt she may not have legitimately owed because she was 81 years old and living alone, and the idea of a lien on her home was simply too frightening to fight. Miguel met with Eleanor in her living room. He brought David's business card. He told Eleanor what David had found about the revenue optimization discussions in the board meeting minutes. Eleanor listened quietly. When Miguel finished, she said that she had suspected something was wrong, but had not known what to do about it, and had not had the resources to fight. She had paid $612 that she may never get back, and she had been alone in her fear because nobody had told her what she now knew. Miguel went home from Eleanor's house and sat at his kitchen table for a long time. Rosa came in and found him there. She asked what he was thinking. He said he was thinking about what it meant that an 81-year-old widow on Social Security had borrowed money from her daughter to pay fines to an HOA that was treating enforcement as revenue optimization. He said he was thinking about all the other people in this community who had paid fines they did not owe because they were afraid. He said he was thinking about what responsibility he had to those people now that he knew what he knew. Rosa sat down across from him. She reached across the table and took his hand. She said she thought he already knew what he was going to do. He did. David had been practicing HOA law for 25 years. In those 25 years, he had seen a lot. He had seen boards that made honest mistakes and corrected them when challenged. He had seen boards that were negligent but not malicious. He had seen boards that were aggressive but operating within their legitimate authority. And he had seen boards that had crossed the line from aggressive governance into something that the law recognized as actionable misconduct. The Sunrise Pines board under Richard, David told Miguel, had crossed that line. The combination of what David had found was not just a collection of individual procedural errors. It was a documented pattern of conduct that had specific legal implications. The revenue optimization discussion in the board meeting minutes was the most significant single piece of evidence. It documented that the board president had explicitly reframed the HOA's enforcement and lien powers as financial tools rather than community management tools. This framing was directly relevant to legal claims of breach of fiduciary duty, which is the duty that HOA board members owe to the homeowners they govern. Board members have a legal obligation to act in the best interests of the community they serve. Using the association's enforcement mechanisms as revenue generation tools at the expense of homeowners' property rights was not acting in the interest of the community. It was acting against it. The specific procedural violations in the Rodriguez case compounded this. The improper initial fine level, assessing a $200 fine for a first offense that the governing documents clearly designated for a written warning. The denial of legitimate appeals without substantive response. The failure to provide adequate pre-lien notice before filing the lien. Each of these was a specific violation of either the governing documents or the state HOA statute. And the broader pattern of enforcement, the disproportionate fines, the systematic denial of first offense warnings, the revenue-focused approach, gave Miguel's specific situation a context that transformed it from an individual dispute into evidence of a systemic pattern. David built a strategy with 3 components. The first component was the direct legal challenge to the Rodriguez lien. He prepared a motion to have the lien declared void on the grounds of the improper initial fine assessment, the procedural defects in the appeal process, and the failure to provide adequate pre-lien notice. This motion, if successful, would eliminate the immediate threat to the Rodriguez property. The second component was a demand letter to the HOA board, the management company, and each individual board member personally. The letter laid out every legal issue David had identified, cited the board meeting minutes revenue optimization language specifically, and demanded comprehensive relief, including the withdrawal of the Rodriguez lien, a full audit of all fines and liens issued under the current board's tenure, refunds of all improperly assessed fines, and the removal of Richard from the board presidency. The third component was a parallel homeowner mobilization effort. David had recommended and Miguel had agreed that the legal action would be significantly more powerful if it was accompanied by a formal community response. A petition signed by a significant number of Sunrise Pines homeowners demanding an emergency board meeting, requesting a full accounting of fine and lien activity under Richard's presidency, and calling for his removal from office. Miguel drafted the petition himself. He worked on it at his kitchen table over 2 evenings, reading it to Rosa and revising it based on her input. He kept it factual, measured, and specific. It described the revenue optimization language in the board meeting minutes. It documented the pattern of improper fine assessments. It named the Rodriguez lien as a specific example. It demanded transparency and accountability. He printed 50 copies and spent a weekend going door to door. He collected 41 signatures in 2 days. 41 homeowners in a community of 218. Nearly 20% of the community. In 2 days. Each signature represented a household that had either experienced something similar themselves or that understood immediately upon reading the petition and the board meeting minutes excerpt that something was fundamentally wrong with how their community was being governed. When Miguel brought the signed petition to David, David looked at the 41 signatures for a long moment. Then he said that this community was about to have a very different HOA board. David filed the motion to void the Rodriguez lien in civil court on a Thursday morning. He simultaneously sent the demand letter by certified mail to the HOA management company, to each board member at their home address, and to the HOA's attorney. He also sent copies to the management company's own parent company, a large regional property management firm, attaching the board meeting minutes with the revenue optimization language highlighted. The response came faster than either David or Miguel had expected. Within 48 hours of the demand letter being received, David had a call from the HOA's attorney, a woman named Sandra who was clearly operating under significant pressure from her client. Sandra opened the call by trying to minimize the revenue optimization language in the board minutes. She characterized it as an inelegant phrasing of a legitimate concern about ensuring the association had adequate reserves. David let her finish. Then he read her the passage again, slowly and completely, including the part where Richard had described the fine and lien authorities as underutilized assets and had presented projected revenue figures based on his proposed enforcement protocols. Sandra was quiet for a moment. Then she said she would need to speak with her client and call back. She called back the following day. The HOA was prepared to discuss resolution of the Rodriguez matter specifically, she said. David told her that a resolution of the Rodriguez matter specifically was not adequate. The demand letter had identified issues that affected the entire community, and any resolution would need to address those issues comprehensively. He referenced the 41 signatures on the community petition. He referenced the court filing. He referenced the management company's parent company, to whom he had copied the demand letter and the board minutes. That last point produced the most significant reaction. The management company's parent company had apparently been in contact with the local management company almost immediately upon receiving David's letter. A management company whose client HOA board was documented in official minutes discussing enforcement as revenue optimization had significant liability exposure of its own. The parent company was not pleased. Over the following 2 weeks, the negotiations moved on 2 simultaneous tracks. The legal track, where David's motion to void the lien was working its way through the court process, and the settlement track, where David and Sandra were negotiating the broader resolution. Miguel was part of every significant decision in the settlement negotiations. He and David spoke almost daily during the 2 weeks the negotiations were most active. David would summarize where things stood, explain what the HOA was offering, and ask Miguel what his priorities were and what he was willing to accept. Miguel, like Jennifer in the earlier story, had been very clear about his priorities before the negotiations began. The lien had to go. Completely. not negotiated down, not paid at a reduced amount, void and removed. The Rodriguez family had not legitimately owed the $200 fine in the first place, and they were not going to pay anything as a condition of having a void lien removed from their home's title. The improper fine had to be formally withdrawn, not just informally waived. He wanted a written acknowledgement that the fine had not been properly assessed under the governing documents. There had to be a comprehensive audit of all fines and liens issued under the current board, with refunds issued for all improperly assessed amounts. Eleanor's $612 was specifically on his list. Richard had to be removed from the board presidency, and the HOA had to adopt formal enforcement procedures that required first offense warnings before fines could be assessed, mandatory substantive responses to homeowner appeals, and mandatory written pre-lien notice with a minimum cure period before any lien could be filed. These were Miguel's terms. He communicated them clearly to David, and David communicated them clearly to Sandra and to the management company. The management company, operating under pressure from its parent company, was the most significant driver of the resolution. They had been copied on everything. They had seen the board meeting minutes. They had seen the petition signatures. They had seen the court filing. They had understood quickly and clearly that their continued association with a board that was documented as treating enforcement as revenue optimization created liability for them that they were not willing to carry. They told Richard that the management company would not continue to service the Sunrise Pines HOA under its current leadership if the situation was not resolved. That message, delivered directly and privately to Richard, appears to have been the decisive factor in breaking the impasse. The settlement agreement was finalized on a Tuesday afternoon, 3 months and 1 week after Miguel had first found that violation notice tucked under Carlos's windshield wiper. The Rodriguez lien was formally voided and removed from the title. A court order confirming the void status was filed in the public record so that any future title search would show the lien as void rather than outstanding. The original $200 fine was formally withdrawn in writing. The settlement agreement contained a specific written acknowledgement that the fine had been assessed at an incorrect level under the governing documents fine schedule. A comprehensive audit of all fines and liens issued during Richard's tenure as board president was ordered. The audit was to be conducted by an independent accounting firm at the HOA's expense. Results were to be shared with all homeowners. Miguel's legal fees were reimbursed in full. Richard resigned from the board presidency as part of the settlement. His resignation letter, which was carefully drafted and contained no admission of wrongdoing, was sent to all homeowners the same day the settlement was finalized. The Sunrise Pines HOA adopted a comprehensive enforcement procedure reform. First offense warnings were mandatory before any fine could be assessed. All homeowner appeals had to receive a substantive written response addressing the specific arguments raised. Pre-lien notice was required to be sent by both certified mail and regular mail, with a 45-day cure period before any lien could be filed. Fine revenue was explicitly excluded from the HOA's budget projections and financial planning. The audit, which was completed about 8 weeks after the settlement, identified 23 instances of improperly assessed fines over the preceding 2 years. Total improper fine assessments came to $14,300. Refunds were issued to every affected homeowner. Eleanor received a check for $612. David told Miguel about this specifically, knowing what it meant to him. Miguel called Eleanor when the refund checks were distributed. She cried. She told Miguel that she had thought that money was just gone and that she was grateful beyond words that someone had fought for her, even though she had not known it was happening. Miguel told her that it was her neighborhood too, that she had as much right to be treated fairly by her HOA as anyone else, that it should never have taken a fight to make that true, but since it had, he was glad it had been fought. Rosa was in the kitchen when Miguel finished the call with Eleanor. She had heard his side of the conversation. She looked at him when he came in from the back porch. He told her about Eleanor's check. Rosa nodded slowly. She did not say anything for a moment. Then she said that this was why it had been worth it. Not the lien being removed, though that was enormous. Not the fine being withdrawn, though that was right. but Eleanor getting her $612 back. But the young first-time homeowners who would never receive an improper first offense fine because the reform required warnings first. But the families in Sunrise Pines who would never have to feel the specific terror of a lien letter arriving without warning because the new procedures required 45 days of certified mail notice. All of that, Rosa said, because Miguel had refused to pay a fine he did not owe. I want to stop here and make sure everyone watching this fully understands what almost happened to the Rodriguez family. Because I think a lot of people, when they hear the phrase HOA foreclosure, have the same reaction Miguel had when David first explained it. They think it must be exaggerated. They think there must be safeguards. They think surely the system has enough checks built in to prevent something so disproportionate from actually happening. The system does have some checks, but in many states those checks are insufficient. And the gap between where the Rodriguez family ended up and where they almost ended up was much smaller than most people realize. HOA assessment liens are recognized as legal encumbrances on property in virtually every state in the country. The legal framework varies significantly by state, but in most states an unpaid HOA assessment, which includes fines as well as monthly dues, creates a lien on the property. This lien typically has a specific priority position relative to other liens on the property, the details of which vary by state and have been the subject of significant litigation in recent years, particularly relative to first mortgage lenders. Once a lien is in place, the HOA has a legal mechanism to enforce it through foreclosure. The practical details of this process, including minimum debt amounts, required notice periods, judicial versus non-judicial foreclosure procedures, and the homeowner's rights during the process, vary enormously by state. Some states have enacted robust homeowner protections, requiring significant debt minimums, mandatory alternative dispute resolution before foreclosure can proceed, judicial oversight of the entire process. Other states have much thinner protections. In the state where Sunrise Pines was located, at the time of this story, the minimum debt threshold for HOA lien foreclosure was relatively low. The required notice and cure period before foreclosure could be initiated was shorter than in many other states. Judicial oversight of the process was limited. These conditions created an environment where an aggressive HOA board, guided by an attorney willing to use the full extent of the available legal mechanisms, could theoretically initiate foreclosure proceedings over a debt amount that most people would consider shockingly small. I am not telling you this to frighten you. I am telling you this because this is information that every homeowner in an HOA community needs to have. Your HOA's authority over your property is not limited to sending you violation notices and assessing fines. In most states, that authority includes the power to cloud your title, impede your ability to sell or refinance, and in extreme cases to initiate foreclosure proceedings. That power exists whether or not you know about it. And it is much more effectively countered by homeowners who understand it than by homeowners who are blindsided by it when a lien notice arrives in the mail. The specific protections available to you depend on where you live. Some states require minimum debt amounts before a lien can be filed. Some require mandatory mediation or arbitration before foreclosure can proceed. Some require judicial approval of HOA foreclosures. Knowing what your state requires is not optional information for HOA homeowners. It is essential, and knowing your HOA's own governing documents is equally essential. In many cases, like Miguel's, the most important protections are not in state law, but in the HOA's own documents. The fine schedule that required a first offense warning. The appeal process that required a substantive response. These were protections that existed in writing before Miguel ever received his first violation notice. He did not know to look for them until he had a reason to. But they were there. Read your documents. Know your state's HOA statute. These two things alone will put you in a fundamentally different position than the position Miguel was in when he opened that first violation notice thinking it was a misunderstanding. The Rodriguez story is different from the other cases we have covered on the HOA files in ways that go beyond the stakes involved, though the stakes here were certainly higher than any story we have told before. It is different because of what it reveals about the specific mechanisms of HOA power and about the specific way that power can be turned against the people it is supposed to serve. Most HOA horror stories are about rules, about absurd restrictions, about petty enforcement, about a neighbor with a clipboard who decides that your welcome mat or your vegetable garden or the color of your front door is a personal affront. These are real problems, and they deserve to be taken seriously, but they exist in a register that is fundamentally recognizable to most people. A neighbor being unreasonable about rules is something most of us have encountered in some form at some point in our lives. The Rodriguez story is not about a neighbor being unreasonable about rules. It is about an institution using legal mechanisms designed to enforce community standards as instruments of financial extraction. It is about a board president who sat in an official meeting of a residential governance body and discussed the association's fine and lien powers as underutilized revenue assets. It is about the specific danger that exists when the people entrusted with governing a community start thinking of that community as a resource to be exploited rather than a trust to be served. This is not an isolated phenomenon. It has been documented in HOA communities across the United States. The specific form varies. Sometimes it is a management company with a financial stake in fine revenue advocating for aggressive enforcement. Sometimes it is a board president with a control orientation who has reframed the association's punitive powers as primary governance tools. Sometimes it is a community that has drifted into a pattern of treating fine and lien revenue as a budget line item without anyone ever explicitly articulating that this is what is happening. But wherever it occurs, the underlying dynamic is the same. An institution that was created to serve homeowners has started treating homeowners as the resource from which its operation is funded. And the homeowners who are most vulnerable to this dynamic are the ones who do not know that it is happening, who do not know their rights, who pay the fines they do not owe because they are afraid of exactly what Miguel almost faced, and who subsidize the system's operation through their compliance. The 41 homeowners who signed Miguel's petition were not all people who had been victimized themselves. Some of them signed because they had heard about the board meeting minutes and were appalled. Some signed because they had received notices that seemed questionable but had paid without understanding they had options. Some signed because they understood intuitively that a community where people are afraid of their HOA is not functioning as a community at all. That intuition is correct. A community where residents are afraid of their governing association is a community where the relationship between the institution and the people it serves has been inverted, where the power flows in the wrong direction, where the tools of governance are being used against governance's purpose. Fixing that inversion in Sunrise Pines as in Sycamore Ridge as in Maplewood Estates required people who were willing to fight, who understood that the fight was not just for themselves, but for everyone in the community, who found each other and built coalitions and hired experts and refused to be intimidated by the mechanisms of institutional power, even when those mechanisms were being aimed directly at their homes. There's a specific person I want to talk to for a moment. Not the person dealing with a petty fine dispute. Not the person who received a violation notice for a welcome mat and needs to know how to fight back. I'm talking to the person who has already escalated past that. The person who has received a lien notice. The person who has opened their mail and found documentation that their HOA has filed a legal claim against their home. The person who is sitting right now with that piece of paper in their hands, feeling the specific cold terror that Miguel felt when David first explained what it meant. I want to tell you something directly and without softening it. The situation is serious. It is not a bluff. It is not a scare tactic with no legal substance behind it. An HOA assessment lien is a real legal instrument, and it needs to be taken seriously. You cannot wish it away or wait it out or assume it will resolve itself. But it is also not hopeless. Not by a long distance. Here is what you need to do immediately. The first thing is to call a property and HOA law attorney today. Not tomorrow. Not when you have had time to think about it. Today. An HOA assessment lien and the foreclosure mechanism it enables is exactly the kind of situation that warrants emergency professional attention. The sooner an attorney is involved, the more options you have and the more time you have to exercise them. When you call that attorney, have your documents with you. The lien notice, the original fine notices, all correspondence with the HOA and management company, your HOA's governing documents, whatever records you have been keeping of this dispute. If you have not been keeping records, tell your attorney that honestly, they can work with what you have. Ask your attorney specifically about the following things: whether the underlying fine or assessment was properly assessed under your governing documents, whether the pre-lien notice requirements under your state's HOA statute were properly followed before the lien was filed, whether the amount of the lien includes any items that were improperly calculated or added, whether your state has any protections that limit HOA foreclosure power, and whether those protections apply to your situation, and what the timeline looks like from the lien filing to any potential foreclosure action, so that you understand exactly how much time you have to work with. The second thing is to request a formal hearing from your HOA board. Most HOA governing documents give homeowners the right to a formal hearing before foreclosure proceedings can be initiated. Assert that right in writing. Have your attorney help you draft the hearing request. This does the two things that formal requests always do in these situations. It puts your position on the record, and it demonstrates to the HOA that you are not going to quietly comply. The third thing is to research your state's specific HOA statute. Your state's legislature website will have a text. Search specifically for provisions about HOA assessment liens, the required process before a lien can be filed, the required process before foreclosure can be initiated, and any minimum debt amounts or other limitations on the HOA's foreclosure power. This research is not a substitute for professional legal counsel, but it will help you have a much more informed and productive conversation with your attorney. The fourth thing is to document everything from this point forward. Every piece of mail, every phone call, every email, every interaction with anyone from the HOA or management company. Date and describe everything. This documentation is the foundation of whatever legal strategy your attorney develops. And the fifth thing is to understand that you are not alone and that people in exactly this situation have fought and won. Miguel Rodriguez sat at his kitchen table with a lien notice against his home, and he fought. He found his David. He built his coalition. He documented everything, and he refused to comply with something unjust even when the cost of refusing felt frightening. And the lien was voided, and the fine was withdrawn, and $14,000 was returned to his community, and Eleanor got her $612 back. Your situation may not resolve exactly the way Miguel's did. Every case is different, and I am not making you any promises. But I'm telling you that having a real attorney, real documentation, and a real understanding of your rights changes everything. From the moment Miguel hired David, the situation started moving toward resolution. Not immediately, and not without difficulty, and not without cost. But it started moving. Because the HOA knew, from the moment David's demand letter arrived, that the Rodriguez family was not going to quietly accept what was being done to them. Make that same decision. Today, I spoke with Miguel and Rosa about 8 months after the settlement was finalized. They were doing well. The lien had been removed. The court order confirming its void status was on file. Their title was clean. Their home was theirs, unencumbered, exactly as it had been before any of this started. Miguel had been elected to the Sunrise Pines HOA board in the special election held after Richard's resignation. He had not particularly wanted to run. He had resisted the idea for a while. But David had encouraged him, and Rosa had encouraged him, and several neighbors, including Eleanor, had encouraged him in terms that made it difficult to say no. They said that the community needed people who understood what had happened to be part of making sure it never happened again. Miguel was serving as board treasurer, which meant he had direct oversight of the association's financial records, including all fine and assessment data. He told me that one of the first things the reconstituted board had done was formally amend the HOA budget to remove fine revenue as a projected line item. Fines were now treated as incidental and unpredictable, logged when they occurred but not counted on as a revenue source in the annual budget. This single structural change, Miguel said, removed the financial incentive for aggressive enforcement that had been built into the previous board's operating philosophy. He told me about his first board meeting as a member. He said that there was a moment early in the meeting when he looked around the table at the other board members and out at the small audience of homeowners who had come to the meeting, and he thought about what this room had represented 12 months earlier and what it represented now. 12 months ago, this room had been where Richard had discussed underutilized assets and revenue optimization. Now it was where neighbors sat together and talked about how to maintain their shared community fairly and transparently, and in a way that served everyone who called a home. He said it was a simple thing when you described it. Just people in a room. But the difference between what that room had been and what it was now felt enormous to him. Rosa was less philosophical about it, in a way that Rosa tended to be less philosophical and more direct. She told me that what she wanted people to take from their story was simple. She said that when you receive an unjust notice about your home, the most important thing you can do is refuse to let fear make your decisions. She said that fear was the entire mechanism. The HOA, in the version they had experienced, was counting on fear, counting on homeowners calculating that it was less frightening to pay than to fight, counting on the lien and the foreclosure mechanism being so frightening as threats that the threat alone would produce compliance. She said that the moment you decide that you are not going to let fear make your decision, you change the entire dynamic. You're no longer a target. You are an opponent. And an informed, documented, legally represented opponent is a very different thing than a frightened homeowner writing a check to make a problem go away. I asked her if she was afraid when David told them about the lien. She did not hesitate at all. She said yes. Absolutely terrified. She said that for about 3 days after David's call, she had trouble sleeping, and she had found herself walking through their house at night and touching things, the walls, the door frames, the kitchen counter, as if making sure it was real and still there and still theirs. She said she was afraid, and she said they fought anyway. And she said that is exactly what she wants every homeowner who hears this story to understand is possible. You can be afraid and still fight. You can feel the fear completely and still refuse to let it be the thing that decides. Carlos was in the kitchen during part of my conversation with Rosa. He was 17 now, about to start his senior year of high school. He heard the last part of what his mother said. When Rosa finished, he looked at her for a moment and then said, quietly, that he was glad they had fought. Rosa looked at him. She said she was glad too. There are 370,000 homeowners associations in the United States. They govern approximately 40 million households and over 100 million individual Americans. In the vast majority of those communities, the HOA functions more or less as intended. The common spaces are maintained. The rules are enforced reasonably. The monthly dues fund the amenities that make the community what it is. The board members are volunteers doing a job nobody else wanted and mostly doing it with reasonable care and good intentions. But in some of those communities, something has gone wrong. A Richard has taken over the board. A revenue optimization philosophy has crept into the governance culture. The fine and lien mechanisms that exist as last resort enforcement tools have been quietly repositioned as primary instruments of community finance. And the homeowners in those communities, most of whom have no idea this is happening until a notice arrives in their mailbox, are living on property that is more encumbered than they know. The Rodriguez story is a story about what happens when a homeowner discovers this and decides to do something about it. It is a story about the specific legal mechanisms that give HOAs extraordinary power over homeowners' most valuable assets. It is a story about the gap between what most people believe HOA enforcement authority means and what it actually means in the states where those laws are most permissive. And it is a story about the irreducible power of a family that refuses to let fear make their decisions. A construction manager who kept every notice in a manila folder and hired the right attorney and went door to door with a petition. A school administrator who recognized the pattern of an institution doubling down and said find a lawyer. Two parents who sat at a kitchen table with a lien on their home and said this is not right and we're going to make it right. Miguel and Rosa did not win because they had extraordinary resources or extraordinary expertise or extraordinary luck. They won because they documented everything, because they found the right professional help, because they built a coalition with their neighbors, and because they refused at every moment when compliance would have been easier to accept that unjust institutional power had the final word over their home. Your home is yours. The rules exist to serve you, not to be weaponized against you. The board works for the community, not the other way around. And the lien and foreclosure powers that your HOA may hold are real and serious and deserve to be understood. Not feared in ignorance, but known clearly so that you can protect yourself and your family and your home. Know your CC and RS. Know your state law. Keep your records. Find your David. Build your coalition. And if a notice arrives in your mailbox that tries to make you choose between your rights and your home, remember Miguel and Rosa Rodriguez, who chose their rights and kept their home. Because those two things are not actually in conflict. Not when you know how to fight. This has been the HOA Files. If this story affected you, if it scared you or educated you or made you think about your own situation differently, please share it with every homeowner you know. The information in this video could be the difference between someone losing their home and someone keeping it. Subscribe for new cases every week. Drop your story in the comments, and I will see you in the next one.